Hey everybody, this one is called Malicious Prosecutions. First of all, I'm not a liar. Well, I mean a lawyer. No, I mean a liar. You should never take my word for anything. You should always do your own research. I have provided references to aid you in your research, but I don't know everything and I'm open to any ideas. There's four types of people you'll meet in your life. There's the people who try to wake up the slaves. There's the slave masters. There's the people who have no idea they're slaves. And there's the people who like being slaves. Which one are you? Do you really know for sure? Are you who you think you are? If you can see through the illusion, then you are the solution. If the people don't know their basic rights and freedoms, how can they possibly know when or if their rights and freedoms are being infringed? Never forget, the men who started this country were marijuana-growing, whiskey-drinking, tax-evading rebels who left their beds at night to shoot at the cops. That's true. All tyranny needs to gain a foothold is for people of good conscience to remain silent. Government is not reason, it is not eloquence, it is force. Like fire, it is a dangerous servant and a fearful master. Well said, George Washington. Don't forget to subscribe to this YouTube channel. Don't forget to follow me on Steemit at Sovereignty International. Don't forget to like this video on YouTube. Don't forget to click the bell next to the subscribe button so you're notified when there's a new upload. And on Steemit, don't forget to vote and make your comments. This is the front page of my channel. The subscribe button's already been clicked, otherwise it would be red. And the bell hasn't been clicked. The arrow's pointing at the bell. You click the bell and a pop-up will come up, and you have to check a box and say you want to be notified of updates. Okay, so this is Article 13 of the Libre Code. Military jurisdiction is two kinds. First, that which is conferred and defined by statute. Second, that which is derived from the common law of war. Military offenses under statute law must be tried in the manner therein directed, but military offenses which do not come within the statute must be tried and punished under the common law of war. The character of the courts which exercise these jurisdictions depends upon the local laws of each particular country. In the armies of the United States, the first is exercised by court-martial, while cases which do not come within the rules and articles of war or the jurisdiction conferred by statute on court-martial are tried by military commissions. Article 13 of the Libre Code, that means there's no Article 3 courts. They're all military commissioners. And that's all over the country, too. Not just in Texas. All statutes are in support of the martial law. All statutes apply to subjects only. There's two kinds of court proceedings, court-martial and military commissions. The only Article 3 courts are set up by we the people, as in common law juror assemblies. We have the Republic of Texas. There's a national as well, common law juror assembly conference call. So I would encourage everybody who's listening to this get involved, because that's the only way you're going to have an Article 3 court. Where a controversy is of such a character as to require the exercise of the judicial power defined by Article 3, jurisdiction thereof can be conferred only on courts established in virtue of that article, and Congress is without power to vest that judicial power in any other judicial tribunal, or, of course, in an executive officer or administrative or executive board, since they are incapable of receiving it. And that's Williams versus United States, 1933. So, you know, they can sit there and do all sorts of stuff, but it's immaterial, because those courts are incapable of receiving Article 3 power. It is noted as significant that the Act constituting the court dispenses with trial by jury, a provision which was distinctly upheld in spite of the Seventh Amendment in Elrath versus United States, that's Supreme Court. With respect to the status of the court, the opinion concludes a duty to give decisions which are advisory only, and so without force as judicial judgments, may be laid on a legislative court, but not on a constitutional court established under Article 3. And that's the same case, Williams versus United States. So the point being is that these legislative courts only give advisory decisions only that do not have the force of law. You volunteer. United States versus Williams. This is a different case, 1992. Because the grand jury is an institution separate from the courts, over whose functioning the courts do not preside, we think it clear that as a general matter, at least no such supervisory judicial authority exists. Grand jury is completely out of control of the government. It's talked about in the Fifth Amendment. This is the same case. This one, I think, is the one that Scalia wrote the decision. Rooted in long centuries of Anglo-American history, the grand jury is mentioned in the Bill of Rights, but not in the body of the Constitution. It has not been textually assigned, therefore, to any of the branches described in the first three articles. It is a constitutional fixture in its own right. So again, it's completely out of the control of judges and lawyers. In fact, the whole theory of its function is that it belongs to no branch of the institutional government, serving as a kind of buffer or referee between the government and the people. Same case. Recognizing this tradition of independence, we have said that the Fifth Amendment's constitutional guarantee presupposes an investigative body acting independently of either prosecuting attorney or judge. Same case. Legislative courts are not judicial. Legislative courts are not Article 3 courts. Legislative courts give advisory decisions only that do not have the force of law. Executive, administrative, executive board, or legislative courts are incapable of receiving authority to be an Article 3 court. Only an Article 3 court has the force of law. And that's not an Article 3 court there, by the way. Judge works for the state, prosecutor works for the state, police or witness works for the state. The vast majority of the disputes that the police initiate on behalf of their employer are also adjudicated by their employer, where the plaintiff, the judge, the antagonist, the police, and the only witness, also the police, all represent the same party. And since no corpus delicti, mens rea, or acts reus can be produced, doesn't technically qualify to be heard according to its own laws. The state, therefore, is indistinguishable from a criminal cartel, and that's exactly what they are, is a criminal cartel. They're nothing but thieves. And they only give advisory decisions. Oh, look at that. There's a kangaroo court. Gee, look at all the kangaroos. We can't even begin to count the number of times judges, lawyers, or statesmen have said there isn't any common law anymore, it's been replaced by statutes. They would be more truthful if they said there isn't any common law anymore, it's been replaced by martial law. And that's taken from the non-ratification of the 14th Amendment by Judge A.H. Ellett to the Utah Supreme Court in the case Diet versus Turner. Martial law supersedes and replaces common law. Statutes have been passed extending the courts of admiralty and vice-admiralty far beyond their ancient limits, for depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property, to supersede the course of common law, and instead thereof to publish and order the use and exercise of the law martial, and for altering fundamentally the form of government established by charter. We saw the misery to which such despotism would reduce us. Military dictatorship, folks. And that's taken from the causes and necessities for taking up arms in 1775. The founding fathers knew what was going on, didn't they? There are no common law offenses against the United States, only those acts which Congress has forbidden with penalties for disobedience of its command or crimes. Under Texas law, no act or omission is a crime unless made so by statute. The legislature may create an offense in the same enactment, provide exceptions to its applications. It's all part of a military dictatorship. All common law offenses and affirmative defenses are abolished. No conduct or omission constitutes an offense or affirmative defense unless it is an offense or affirmative defense under this title or under another statute or ordinance. And that's Arizona revised statutes. NSA takes care of the spying, CIA takes care of the drug trade, FBI takes care of the terror attacks and false flags, Homeland Security takes care of the rest. Now, I gotta tell you that I used to work at U.S. Airways, and I saw their air agency certificate. Okay, so U.S. Airways, and now it's called American Airlines, but I guarantee you they have a air agency certificate. So think about it. All airlines are agencies of the Department of Transportation. think about it. Well, so what do you think about the National Security Agency? Do you think maybe it's a private corporation that's owned by somebody? And the Central Intelligence Agency, do you think it's a private corporation that's owned by somebody? And so if that's the case, then what do you think they do with their intelligence? Yes, they certainly turn it over to U.S. people and U.S. sources, but do you think that's all they're doing with it? And do you think maybe they have other people that they're working for the same company that are doing stuff that's maybe false flag operations or things like that? Do you think maybe that might be going on? What do you think? The CIA owns everyone of any significance in the major media. And that's William Colby, former CIA director. Boy, that's obvious nowadays. I mean, the media, the mainstream media, can't be trusted for a second. They nothing but lie. We'll know our disinformation program is complete when everything the American public believes is false. Boy, ain't that the truth. Well, we don't believe it. That's the problem. Nobody believes them anymore. Deception is the state of mind and the mind of the state. Yep. And now we're going to talk a little bit about Libre Code. Okay, and this is again talking about malicious prosecution. So we're going to get into that towards the end. Instructions for the government of the armies of the United States in the field. It's prepared by Francis Libre, promulgated as General Orders Number 100 by President Lincoln on the 24th of April in 1863. It's available at the U.S. Government Printing Office, and you can easily get it online. Article 1 of the Libre Code, the underlined section, is martial law is the immediate and direct effect and consequence of occupation or conquest. The President of the hostile army proclaims its martial law. So the fact that the army was here is martial law. And then martial law does not cease during a hostile occupation except by special proclamation ordered by the Commander-in-Chief or by special mention in the Treaty of Peace. And that's Article 2 of the Libre Code. So at least in Texas' case, there's been no proclamations. Well, there hasn't been any proclamations, period, in America. And there's been no treaties of peace with Texas or any of the southern states. There's been no, there was no, all there was a, I think there was a ceasefire, is all there was with the Confederacy, and that was it. And and the same thing applies with the area taken by the Treaty of Hidalgo, which is Mexico, New Mexico, Arizona, Nevada, Utah, maybe parts of Colorado. I'm not sure about Colorado. Anyways, this is Article 3 of the Libre Code. Martial law in a hostile country consists in suspension by the occupying military authority of the criminal and civil law and of the domestic administration of government in the occupied place or territory, and in the substitution of military rule and force for the same, as well as in the dictation of general laws. That's dictatorship, folks. As far as military necessity requires the suspension, substitution, or dictatorship. Okay, so everything that goes on under martial law is at the pleasure of the commander. And this is taken from the non-ratification of the 14th Amendment by Judge A.H. Ella to the Utah Supreme Court. And this is talking about Article 3 of the Libre Code. Anyways, it says, note, under the law martial, only the criminal jurisdiction of a military court is the recognized law. But as Article 3 says, the civil courts can continue wholly or in part as long as the civil jurisdiction does not violate the military orders laid down by the Commander-in-Chief or one of his commanders. By this means, a military venue, jurisdiction, and authority are imposed upon the occupied populace under the disguise of the ordinary civil courts and officers of the occupied district or region, because the so-called civil authorities in an occupied district or region only act at the pleasure of a military authority. So you think it's nice and peaceful out there, but it's all martial law. It should be noted here that the several state legislatures, county boards of commissioners, and city councils are constantly legislating to please the edicts of the federal government, the occupying force, and that their legislation in this sense is not an exercise of state sovereignty, but instead a compliance with the edicts of the military force which occupies the several states, and consequently are edicts of martial law rule. Edicts, as in dictatorship, folks. Statutes equals edicts under martial law. Regulations equals edicts under martial law. A code equals edicts under martial law. A rule equals edicts under martial law. Even a constitution equals edicts under martial law. A constitutional amendment equals edicts under martial law. You know, if you send a registered letter to the Secretary of State and asking them for a certified copy of the Texas Constitution, you know which one you'll get? You'll get the 1836 Constitution. Because that's the only one that's the real Constitution. There is no other Constitution. That's the Republic of Texas too, by the way, I'd like to add. Article 44 of the Libra Code. All wanton violence committed against persons in the invaded country, all destruction of property not commanded by the authorized officer, all robbery, all pillaging or sacking, even after taking a place by main force, all rape, wounding, maiming, or killing of such inhabitants are prohibited under penalty of death, or such other severe punishment as may seem adequate for the gravity of the offense. A soldier, officer, or private in the act of committing such violence and disobeying a superior ordering him to abstain from it may be lawfully killed on the spot by such superior. Ooh, that's pretty drastic, but that's the truth, and that's what starts the good faith doctrine, and you're going to see it all over the place. And here's a great place right here, the Texas Code of Criminal Procedure, Article 38.23, evidence not to be used. And this sounds so pretty. This is an edict under martial law too, by the way. This says, no evidence obtained by an officer or other person in violation of any provisions of the constitutional laws of the state of Texas or the constitutional laws of the United States shall be admitted in evidence against the accused on the trial of any criminal case. Whoa, doesn't that sound like you got so many wonderful rights? Woohoo! But then, paragraph B. It is an exception to the provisions of subsection A of this article that the evidence was obtained by a law enforcement officer acting in objective good faith reliance upon a warrant issued by a neutral magistrate based on probable cause. Well, there's no such thing. What a scam. And it's federal codes too. This is actually, it's 18 U.S.C. 2707. Actually, USC is actually another word for District of Columbia Code. Anyway, civil action. This is another edict under martial law. A defense, a good faith reliance on a court warrant or order, a grand jury subpoena, a legislative authorization, or a statutory authorization, including a request of a governmental entity under Section 2703F of this title, a request of an investigative or law enforcement officer under Section 2518.7 of this title, or a good faith determination that 2511.3 of this title permitted the conduct complained of, is a complete defense to any civil or criminal action brought under this chapter or any other law. Yeah, so they can just go ahead and just murder people and get away with it. They're authorized. Copies of these documents can be found in my private group at Yahoo called Administrating Your Public Servants. For a complete set of YouTube videos with private information shares, a DVD with over 50 searchable law dictionaries and other books and forums, contact me privately at engineerwin@yahoo.com. Donations to support this work are appreciated. I prefer a gold or silver coin, but as an extremely less desirable alternative, I can accept the military script, the fake money, the IOUs, the Federal Reserve notes, the PayPal gifts, the checks, the money orders, etc. Send me an email for particulars. All statutes, codes, rules, and regulations, and constitutions are edicts under martial law. Every constitutional amendment after 1861 is an edict under martial law. Military necessity equals martial law. All Civil War states are under a military occupation: Virginia, North Carolina, South Carolina, Georgia, Florida, Alabama, Mississippi, Louisiana, Arkansas, Texas, Missouri, Tennessee, and Kentucky. All of the states in the territory conquered in the war with Mexico are under military occupation: Arizona, New Mexico, Utah, Nevada. Dictation equals dictatorship, as in military dictatorship. Law enforcement, that's why they call them law enforcement officers, because they're enforcing the martial law. It's exactly what's going on, folks. When the southern states walked out of Congress in 1861, they ceased to have a quorum. And under executive authority, martial law, Lincoln ordered Congress to reconvene. When the Supreme Court ruled against something that Lincoln did, he ordered troops to the Supreme Court. And to this day, you go look up the rules of the Supreme Court. Rule 45. All process of this court issues in the name of the President of the United States. There's no separation of powers, folks. There never has been. It's a military dictatorship since the Civil War. All statutes, state or federal, passed prior to 1861 are lawful de jure statutes. All statutes, state or federal, passed after 1861 are martial law statutes. Two national governments exist, one to be maintained under the Constitution with all its restrictions, the other to be maintained by Congress outside and independently of that instrument. And that's the dissenting opinion in the case Downs versus Bidwell in 1901. And so, again, the other to be maintained by Congress outside and independently of that instrument. In other words, it's unconstitutional. In 1871, Congress set up the corporation to operate as the government of District of Columbia, and that's the one. It's an established fact that the federal government has been dissolved by the Emergency Banking Act, March 9, 1933, 48 Stat 1, Public Law 89-719, declared by President Roosevelt being bankrupt and insolvent. House Joint Resolution 192, 73rd Congress in session, June 5, 1933, Joint Resolution to suspend the gold standard and abrogate the gold clause, dissolve the sovereign authority of the United States and the official capacities of all governmental offices, officers, and departments, and is further evidence that the United States federal government exists today in name only. And that's the United States Congressional Record, March 17, 1993, and volume 33. Oh, and look at that. March 9, 1933. Yeah, March 9, 1933, the same day. Since March 9, 1933, the United States has been in a state of declared national emergency. Under the powers delegated by these statutes, the President may seize property, organize and control the means of production, seize commodities, assign military forces abroad, institute martial law, seize and control all transportation and communication, regulate the operation of private enterprise, restrict travel, and in a plethora of particular ways control the lives of all American citizens. The majority of the people of the United States have lived all their lives under emergency rule. For 40 years, freedoms and governmental procedures guaranteed by the Constitution have in varying degrees been abridged by laws brought into force by states of national emergency. And that's the NREG U.S. Senate Report number 93-549, dated November 19, 1973. You can easily find that online. I found it, and I have it in other videos. So there's three kinds of martial law, okay? There's full martial law, where there's a declaration of martial law issued, which actually isn't necessary. Troops are put on the streets, used only during wartime, used on a foreign country when actually invaded by a foreign power or to put down an armed rebellion. There's martial law proper. It's the law of the armed forces. It's when a captain tells a private what to do and enforced by court-martial. And then there's martial law rule, which is the law of necessity and emergency, allows the domestic use of martial law powers, and it's used during peace times. And that's not a cite, okay? That's a summary, and you'd have to read that whole case, Ex parte Milligan, which is located at 4 Wallace 2, or Legal Edition, Book 18 of the Legal Edition 281. Anyways, this is also cited in the non-ratification of the 14th Amendment by Judge A.H. Ellett to the Utah Supreme Court in the case Diet versus Turner. Pentagon Inc., Google, YouTube, Facebook, Amazon, masquerading as private companies. So this right here is how the martial law is imposed everywhere in America. And it's still imposed. Emergency, because of bankruptcy, really, is what it is. And because it's owned and operated by the Roman cult. Everything done after 1861 was done under martial law. In 1933, the District of Columbia was declared bankrupt and seized by its creditors, the Roman cult. All statutes, constitutions, codes, rules, regulations, amendments are for the unconstitutional corporation that was set up in 1871. And there's the Speaker's podium in the U.S. House of Representatives. And you got the two fascists, Roman fascists, on each side of the Speaker's podium. And you also have the staff. That's a Roman military staff that's right here. It's a Roman military staff, and these are fascists right here. And so we're going to go on the next page. It says dictatorship equals Roman cult equals murder and slavery. The Roman Achaea military staff carried in battle by all Roman commands and planted on all conquered nations. And there's a Roman bundle of rods bound to a weapon symbolizing subservient under the rule of a single man, and that's the fascia. So there's two national governments exist under the Constitution, with one to be maintained and under the Constitution with all its restrictions, the other to be maintained by Congress outside and independently of that instrument. And that's, again, I cited that case previously. Martial law falls under the law of nations. This will work for any country on the planet because it falls under the law of nations. Find any national emergency, including a bankruptcy, and you'll have proof that your country is operating under martial law. The military script. If you got military script, okay, fake money, Federal Reserve notes, bank notes, that's all military script, and that's martial law. Martial law extends to property and to persons, whether they're subjects of the enemy or aliens to that government. That's Article 7. Subjects or aliens, nobody else, does not affect the sovereignty. Why would anyone want to be a low-life scumbag U.S. citizen? If a military police officer is talking to you, then you are a subject, and you are the enemy. All subjects over which the sovereign power of the state extends are objects of taxation, but those over which it does not extend are exempt from taxation. This proposition may be pronounced as self-evident. It's obvious. The sovereignty of the state extends to everything which exists by its authority or its permission. That's McCullough versus Maryland, 1819. And it's obvious that that is the case. If you are created by the government, then you're a slave. You're a piece of property. You're owned. If you're not, if they think you are, then you've done some things to get them confused, and you need to stop doing it. It's a contract. The Congress shall have power to dispose of and make all needful rules and regulations respecting the other property belonging to the United States. That's Article 4, Section 3, Clause 2. And that's where you are, your property. If you're a subject, you are property. And this is not just in the U.S., this is everywhere. In the Canadian Ownership and Control Determination Act, it says owned means subject to the regulations. So if you're owned, you're subject to the regulations, you are a piece of property. You are owned. They can do whatever they want with you. There's two jurisdictions, two political jurisdictions. Every tree, living things, plants, animals, plants, heaven, earth, the universe, lawful and natural. And then there's the fictional things, persons and corporations, domicile, resident, legal, and political. And so if you're in the real world, you're gods, and otherwise you're Lucifers. The term resident and citizen of the United States is distinguished from a citizen of one of the several states in that the former is a special class of citizen created by Congress. If you're created by Congress, then you're property. The term citizen of the United States is analogous to the term subject in the common law. Civil rights under the 14th Amendment are for federal citizens, not state citizens. Federal citizens, as parents, have no right to the custody of their infant children. It says subject to the paramount right of the state. So, I've been getting a lot of people contacting me about child protective services. Well, you haven't done anything to make them think that you're not one of their subjects. Okay, and if you're one of their subjects, then you don't have the right to your infant children. So, again, you need to start taking care of business and get on top of things. That's what I would say, is start taking care of business and get on top of things. It's evident that they, U.S. citizens, have not the political rights which are vested in citizens of the states. They are not constituents of any community which is vested in any sovereign power of government. Their position partakes more of the character of subjects than of citizens. They are subject to the laws of the United States, but have no voice in its management. If they are allowed to make laws, the validity of these laws is derived from the sanction of a government in which they're not represented. Mere citizenship they may have, but the political rights of citizens they cannot enjoy. People versus De La Guerra, California, 1870. Article 7 of the Livre Code. Martial law affects chiefly the police in the collection of public revenue and taxes, whether imposed by the expelled government or by the invader. Refers mainly to the support and efficiency of the army, its safety, and the safety of its operations. Now you know why they always want you to be safe. Don't worry, we're just worried about your safety. We just worried about your safety. We want you to be safe. Subjects pay taxes. Do you feel like you have no constitutional rights when it comes to income tax? It's because you don't. The Constitution does not apply. Where two parties have a contractual relationship, you are a subject. You're a piece of property. Be glad they're only taking a little bit, because they could take it all if they really wanted to. All police are military police. FBI military police, city military police, state military police, Homeland Security military police, county military police. All police are military police, and if they're talking to you, then you're a subject and you are the enemy. The real domestic terrorists. You are the enemy. Murdered by police. You know, there's thousands that have been murdered by police. It seems like there's a new one every day almost. You are the enemy. We talked it over, and after investigating ourselves, we decided we're not guilty. Yeah, you are the enemy. Beware violent street gangs. Typical gang member, well organized, gang colors, gang identifier, heavily armed. Do not approach gang members, are aggressively and notoriously violent. You know, and this, I got this in here because Obama was a textbook tyrant. He was absolutely, and this is Aristotle, okay? The tyrant who, in order to hold his power, suppresses every superiority, does away with good men. Okay, so Obama removed anybody in office that whistleblowers and all sorts of stuff like that. I mean, put them in jail. Forbids education and the like, controls every movement of the citizens. Gee, that sounds like the NSA and the CIA, keeping them under perpetual servitude. Gee, that sounds like taxes. And look at all the homeless people. Wants them to grow accustomed to baseness and cowardice. And so that's the military police. They operate in gangs. They never come and face you on their own. Has his spies everywhere to listen to what is said in meetings and spreads dissension and calumny among the citizens. Gee, that sounds like the NSA and the CIA. And impoverishes them. Gee, that sounds like taxes and the homeless people. Is obliged to make war in order to keep his subject occupied and impose upon them a permanent need of a chief. Gee, that sounds like all these wars we've been in. And so then, by definition, Trump is the opposite. Okay, he hasn't been, you know, quite frankly, I think he has to placate the deep state, but he hasn't really. They've moved some troops around and they've done this and they've done that, but there's been, I don't know of any wars. I mean, he went and he did the cruise missile attack in Syria, where he basically attacked an empty military base and told them about it up front. I mean, yeah. So I think Trump is basically the opposite. Anyways, so there's two national governments. Government officials wear two hats. They can represent the unconstitutional corporation, or they can represent the lawful de jure government. Because of our own ignorance, and Mark Passio says ignorance is a compound word, ignorance, spells it that way or pronounces it that way, and that's I'll tell you, I agree with that 100%. Ignorance. We've given them evidence of their slave. They presume we're their slave until we defeat their presumption. Do you know who you are? Under international law of warfare, all parties to a cause must appear by nom de guerre, because the alien enemy cannot maintain an action during the war in his own name. Why do you think they spell the name in all block capital letters? A mixed war is one which is made on one side by public authority and the other by mere private persons. Well, it's all warfare. It's what it is. It's all warfare. The United States acknowledge and protect in hostile countries occupied them religion, morality. Gee, this sounds like the Geneva Convention talking about similar things. Strictly private property, the persons of the inhabitants, especially those of women, and the sacredness of domestic relations. Offenses to the contrary shall be rigorously punished. This rule does not interfere with the right of the victorious invader to tax the people or their property, to levy forced loans. Okay, what do you think those Federal Reserve notes that are circulating are? Those are forced loans. The forced loans of 1862 and 1863 in the form of legal tender notes were vital forces in the struggle for national supremacy. And that's Juilliard versus Greenman, U.S. Supreme Court. And so the point being is that that's how we're going to be able to tell when Trump is able to end the martial law. He'll be close to making a proclamation that ends the martial law. when they shut down the Federal Reserve and they go back to gold and silver coin. Got to get away from this fake money. Federal Reserve notes are military script. Federal Reserve notes are forced loans. They're forcing you, the enemy, to loan the government money. Governments, any sovereign, descend to the level of a mere private corporation and take on the characteristics of a mere private citizen where private corporate commercial paper and securities is concerned. The purposes suit this corporations and individuals are regarded as entities entirely separate from government. Federal Reserve notes equals military script. Okay, my subscription channels. I have exclusive content available on my website. I have 2 subscription levels and I accept cryptocurrencies. $29.99 a year for the videos only, $49.99 a year for the videos plus unlimited consultations. But there are limits as what I can do for the unlimited consultations because I'm not a liar. Well, I meant an attorney. No, actually I meant a liar. But I can tell you what I would do under certain circumstances and where to find the forms. The only power that these New World Order Satanists have over us is through fraud and deception, and my agenda is to expose it for all our benefit, but I cannot fight all the battles. I'm currently publishing a video a week, and so if you want to get a subscription as a donation, it's a modest donation, there's no doubt about it, but it's appreciated. Every little bit helps, and a whole bunch of people chipping in a little bit adds up pretty fast. So anyways, so I can tell you what I would do and where to find the forms. Now there's also some limits because if you want a voice communications, that's extra, and if you want me to review forms and things like that, that's extra. So you know, there's limits as to, and plus, 20 emails in a day, I mean, it's got to be within reason, sort of thing. You know what I mean? Arlington private information share, some of my exclusive content, land deed training, estoppel certificates training, foreclosure estoppel certificates training, corporate denial training, toll roads notice and demand training, invoice training, notice of void judgment training, revocation of signature training, third-party witness training, and federal habeas corpus training. There's also revocation of voter registration training. There's a couple videos for criminal complaint training. There's going to be some lawsuit training, although I haven't done it yet, but I'm going to have to start doing it here pretty soon because there's a lot of people that have been asking me for that. And then other training if there's any requests. There's also I've uploaded some Northeast Private Information Share videos. I've also got the trial videos on how to deal with it when you're dragging you in there, and she's really sharp on equity, okay, and how to get equity come out where you do certain things and all of a sudden the judge becomes your best friend and he's sitting there, what do you wish to do? And so then you can give him your wishes. All forms, files, and other instructions are available for free on my 2 private groups at Yahoo Groups and Google Groups, and all exclusive content is available on my website, and you can buy a subscription there. Yeah, the trial videos are pretty sharp, and she went and at the Northeast Private Information Share, she brought a TLF guy that goes through and explains how he had actually a criminal matter, and there was warrants, and he went and, like, he was at a house. I think it was like there was marijuana there or something, I'm not sure. But anyways, the cops raided the place while he was there. He was just leaving and the cops rolled up. And so they made him stay there, and so he stood there, and there was a warrant for him, and he knew it. And they asked him his name, and he says to him, he says, do you have an oath of office? And the cop says, yes, I do. And he says, well, I accept your oath of office. And so then the cop turns and he starts conducting business with some other people and everything, and at the very end, he comes up to him and he says, well, thanks for accepting my oath of office, and have a nice day. And that was the end of it. And it's amazing how and then plus he had these warrants, and he had to go to court a bunch of times, and he goes through his dilemmas because there was things that the judge did that he didn't know how to deal with or how to follow through, and so she's coaching him while he's doing this, and so it takes him a bunch of appearances, but ultimately he makes this thing go away. Okay, so again, you have to, she's really sharp. I got to tell you, she's really sharp. And so I would highly encourage you to check out those videos. Anyways, war is terrorism on a bigger budget. Sure is. Democracy. Fake laws, false arrest, feel free. This is Article 52 of the Geneva Convention. No contract, agreement, or regulation shall impair the right of any worker, whether voluntary or not, wherever he may be, to apply to the representatives of the protecting power in order to request the said power's intervention. Okay, so they cannot make rules or regulations or anything. Okay, matter of fact, I'm getting ready to file a lawsuit, and in this lawsuit, I'm telling them that I'm not going to affect service. I'm not going to follow your rules. I'm not going to take your orders. I'm not doing anything, and I'm giving you this thing, but you can mail a check to this address, and that's Article 52 of the Geneva Convention. And the term federal personnel, which is an edict under martial law. This is Title 5, United States Code, Section 552 AA 13. Federal personnel means officers and employees of the government of the United States, members of the uniformed services, including members of the reserve components, and individuals entitled to receive immediate or deferred retirement benefits under any retirement program of the government of the United States, including survivor benefits. Well, they're saying anybody with a Social Security number is federal personnel. If they compel the disclosure of a Social Security number, they're compelling you to work for the occupying power. Filing fees are a regulation. That's an edict under martial law. Court rules are a regulation. That's an edict under martial law. By turning on their emergency lights, they're terrorizing you. They're coercing information from you or a third party. That's a war crime. When they coerce a date of birth from you, they're compelling you to work for the occupying power, a war crime. When they use their regulations to deny you justice, it's a war crime. Protected persons are entitled in circumstances to respect for their persons, their honor, their family rights, their religious convictions and practices, and their manners and customs, without prejudice to the provisions relating to the state of health, age, and sex. All protected persons shall be treated with the same consideration by the party to the conflict in whose power they are, without any adverse distinction based in particular on race, religion, or political opinion. And that's Article 27 of the Geneva Convention. When they stop you because you have plates in your vehicle that are not state plates, they're persecuting you for your political opinion. When they drag you into their kangaroo court, they're subjecting you to their satanic religious ceremony. Yet still it was found difficult to set bounds to ecclesiastical ingenuity. For when they were driven all their former holes, they devised a new method of conveyance, which the lands were granted not to themselves directly, but to nominal feocees to the use of the religious houses, thus distinguishing between the possession and the use, and receiving the actual profits, while a season of the land remained in the nominal feoce, was held by the courts of equity, then under the direction of the clergy, to be bound in conscience to account to assesticate use for the rents and emoluments of the estate. Gee, that sounds like taxes. And it is to these inventions that our practitioners are indebted for the introduction of uses and trusts, the foundation of modern conveyancing. And that's taken from Tomlin's Law Dictionary, 1835 edition, volume 2, under the definition of mortmain. My blog is sovereigntyinternational.wordpress.com. My website is sovereigntyinternational.fyi. My email address is engineerwin@yahoo.com. My YouTube profile is Sovereign Living. My Facebook community page, I deleted it due to censorship on the part of Facebook. My private group on Facebook called Sovereignty International is, well, I haven't been there for ages. Facebook's a has-been. You know, they're going downhill. Their history, in my opinion. I don't even go there anymore. I have someone else that manages that group, and they can have at her. I don't go there. I rarely go there. I shouldn't say I don't, but I rarely do. They go and censor everything. Matter of fact, they're being sued right now for censorship by a NGO, a non-governmental organization. Anyways, my Yahoo private group is Administrating Your Public Servants. My Google private group is called Administrating Your Public Servants. Follow me on Twitter at EngineerWin. Follow me on Steemit at Sovereignty International, and I have a BitChute channel, but I don't have everything up there because of the fact that they limit the size of files, and some of my videos are pretty big files. Anyways, protected persons may in no circumstances renounce in part or entirety the rights secured to them by the present convention, and this is absolutely critical. Okay, so, you know, when you do an appeal, they go and look through the records, through the transcript, looking for objections. And if they violated your rights and you didn't object, then you consented. And so, but this is perfect, because war crimes, you cannot give up the rights, like the due process, because that's found in the Geneva Convention too, the right to civilian due process. So you can win an appeal based on war crimes. Article 29 of the Geneva Convention. The party to the conflict in whose hands protected persons may be is responsible for the treatment accorded to them by its agents, irrespective of any individual responsibility which may be incurred. Okay? So their criminal municipal corporation is responsible no matter what. They may be able to get their pigs off the hook, but their criminal corporation is still responsible. And that's why, whenever I said I was getting ready to file a lawsuit, it's like about 250 pages or more. It's about 250 pages. Anyways, in that lawsuit, I am basically telling them, I'm not following your rules. Under Article 52 of the Geneva Convention, you can't make rules to block my ability to get a remedy from you. And under Article 8, I cannot give up those rights. And Article 29, the corporation, no matter who's responsible, the corporation's still responsible. So you can just mail a check to this address. I'm not doing nothing. I'm not affecting service. I'm not doing nothing. So we'll see how it goes. Terrorism is a system of government that seeks to rule by intimidation. Can you spot the terrorists? I can see a whole bunch of them there. Check out my other videos, the Bankster Thieves playlist, the Roman Cult playlist, the Bankrupt Corporate So-Called Governments, Bar Members 1 through 4, Do-It-Yourself How Not to Volunteer for the Selective Service in the Draft, Martial Laws Here, Do-It-Yourself No Income Tax, Do-It-Yourself Free Mail, Do-It-Yourself Kangaroo Courts 1 through 15, Canada Border Pigs playlist, Bar Members and their Satanic Connections playlist. Article 71 of the Geneva Conventions. No sentence shall be pronounced by the competent courts of the occupying power except after a regular trial. That's called due process, folks. It's the fundamental right of a party to have a neutral and detached judge preside over judicial proceedings. Due process, folks. Not a bought and paid for clerk masquerading as a judge. When they deny due process, they lose subject matter jurisdiction, and they're supposed to dismiss it under 12H3, Federal Rules of Civil Procedure. Warning, this is the standing army you were told not to tolerate. Order followers, the servants of evil. You assist an evil system most effectively by obeying its orders and decrees. That's why I told that judge, matter of fact, I call them names all through that lawsuit. I call them bought and paid for judicial whores. I call them whores selling their just us. I call them clerks masquerading as judges. I call them military commissioners, etc., etc. All throughout this thing. Every time I talk about a judge, I'm throwing some of that stuff in there. I mean, I'm telling them that you have no right to turn this thing away. Order followers are the ones that keep the system of slavery in place. Mark Passio, ain't that the truth? Mark Passio, brilliant guy. Highly recommend his channel. It's called What on Earth is Happening. Check out his channel. War is when your government tells you who the enemy is. Revolution is when you figure it out for yourself. When liberty and freedom are at stake, your silence isn't golden. It's yellow. Change will not come if we wait for some other person or some other time. We are the ones we've been waiting for. We are the change that we seek. These Roman cult Satanists are bent over backwards to make you think you have constitutional rights. It's extremely important to them that people do not figure this out, because the last time they were doing war crimes that precipitated a revolution. If you challenge jurisdiction, the so-called judge is required to compel the prosecutor to prove jurisdiction or dismiss the case. If they do anything else, it's a denial of due process. It's a war crime. They're cowards. They're real brave when there's 20 or 30 of them, but when it's just you and them, they're cowards. They sneak around, fabricate evidence that you're the enemy and a subject, and they will never confront you without lots of their buddies to back them up. You are the enemy, and the sooner you figure that out, the better. You are a subject and their slave, and the sooner you figure that out, the better. Samuel Adams coined the phrase, "Give me liberty or give me death," after witnessing a man flogged to death for refusing to take a license. They were assaulting people with their Roman cult Sestake trusts. And these two court cases right here were like in 1796, which is just after the War of Independence when everything was really fresh in their minds. So what are they saying? They're saying, in doing this I shall have occasion incidentally to evince how true it is that states and governments were made for man, and at the same time how true it is that his creatures and servants have first deceived, next vilified, and at last oppressed their master and maker. Gee, do you think that's going on nowadays? A state like a merchant makes a contract, a dishonest state like a dishonest merchant willfully refuses to discharge it. You think that's going on nowadays? Government is not reason, it is not eloquence, it is force. Like fire, it is a dangerous servant and a fearful master. They're taking reprisals for your political beliefs. They're taking reprisals against you because you don't want to be their slaves. They're pillaging your property. They're not respecting your religious beliefs. They're terrorizing you. They're threatening you. They're coercing information from you and from third parties. And if they go to their computer and look up some information in the DMV database, then that's a third party. I hate to tell you that, but that's a third party. Or a FBI database, that's another third party. They're engaging in genocide against state citizens. An employee of the United States is not qualified to serve on a member of a grand jury in any district. Okay, so there's another denial of due process. Because if the jury members were all U.S. citizens, and remember, what's it take to be a U.S. citizen? Gee, a social security number. I wonder how many people on that jury, if you say, do you have a social security number? I wonder how many people are going to say, oh yeah, I got one. This is all coming from the Roman cult bar. And these prosecutors get a royalty for selling you into slavery. That's true. That's in the DC Code. The so-called judge is a military commissioner sitting there playing stupid and letting the prosecutor have his way. This is the Sovereign Citizen Quick Reference Guide that's published by the Joint Terrorism Task Force and the Federal Bureau of Investigation. Sovereign citizen activity typically involves criminal behavior that's generally nonviolent but has led to threats and plots against court officials by the more extremist adherents. Below are some indicators that you have encountered a sovereign citizen during your normal duties, and be a signal that additional precautions against fraudulent filings and personal harm be used. Initial indicators of sovereign citizens, and the reason you want this thing, quite frankly, is because if any of this stuff comes out in a court case, then you have evidence that they're taking reprisals against you for your political beliefs. That's exactly what's going on. And so, presentation to the courts of voluminous motions that contain references to UCC codes. Well, you know, how many people do that? I'll bet you just about everybody, if they're smart, does that. Of course, anybody, I mean, my stuff all has it, for sure. And so, again, they're going to call me a sovereign citizen. They're going to take reprisals against me. And so I got evidence of it. Reference to probate-type language, including estates, trusts, and wills. Yeah, well, I don't want to be their Roman cult sesticate trust. References case law that's outdated or irrelevant. You know, and that's well known that they hire a screen for low intelligence. So one of these low intelligence code enforcers is going to decide whether case law is outdated or irrelevant or taken out of context. Yeah, right. Uses outdated language. Uses red ink and written statements, thumbprints, and their signatures. Yeah. Oh, well, see, don't use red ink. Okay, we're going to take reprisals against you. Presents documents that identify the defendant as a sovereign. Well, you know, I'm afraid the courts have talked about that. Gee, this thing's got treason written all over it, okay? But this is great evidence that you can use, and I'm not going to read the whole thing. This is great evidence. You use this thing, and this is going to be on my Yahoo group. If it's not, let me know. I'll put it there. I'm positive I uploaded it, though. Anyways, this is great evidence that you can use against of war crimes. Remember, it's warfare. You have to treat it like it's warfare because this is exactly what it is. Don't wait for them to attack you. Attack them first. The number one rule of warfare is the best defense is a good offense. The way you attack them is you make an affidavit of corporate denial. You serve them with a notice and demand that's designed to take away their presumptions, and if you do this effectively, it'll put them in a very difficult position. If you do this well, you may even be able to get them fired or worse. You make an affidavit of criminal complaint and serve it on the U.S. attorney when they violate your rights. If they don't, then there's no reason to be doing anything. But chances are, most of them, I've served like thousands and rarely do I ever have to file criminal complaints in relation to the number that I filed, served. This is Texas Transportation Code. If the owner of a motor vehicle fails to pay the amount of the civil penalty imposed against the owner, an arrest warrant may not be issued. See, this is a Class C misdemeanor, okay? The imposition of civil penalty may not be recorded on the owner's driving record, and that's failure to pay a civil penalty, and that's for a Class C misdemeanor. An offense under this section is a Class C misdemeanor if the offense for which the actor's appearance is required is punishable by fine only. Okay, so if you, again, if it's punishable by fine only, it's a Class C misdemeanor. Class C misdemeanor does not impose any legal disability or disadvantage. Individual adjudged guilty of a Class C misdemeanor shall be punished by a fine only not to exceed $500. Class C misdemeanors. Okay, that's Texas Penal Code. County attorney represent the case in the state in all cases, and they don't do that, and so that's a breach of trust. That's a simulated legal process. That's a whole bunch of things. And this is Texas Penal Code, bail jumping and failure to appear. An offense under this section is a Class C misdemeanor if the offense for which the actor's appearance is required is punishable by fine only. So again, it's still a Class C misdemeanor. So a crime, and this is really, really important, and you need to, this is all Texas, so you need to look this stuff in your state, because this is like really important. This is where you can really nail them for malicious prosecution, okay? You can nail them hard. Anyways, a crime is a misdemeanor punishable by confinement or jail, or a felony, okay? That's it. So a Class C misdemeanor is not a crime, because they cannot jail you over it. It's a fine only. A defendant means the person accused of a crime. So if they're calling you a defendant on a Class C misdemeanor, that's prejudged. Okay, they prejudged it. A municipal court, including a municipal court of record, shall have exclusive original jurisdiction within the territorial limits of the municipality in all criminal cases. Well, if it's a Class C misdemeanor, that's not a crime, so they don't have jurisdiction. A municipal court, including a municipal court of record, shall have exclusive original jurisdiction in the municipal territorial limits in all criminal cases that, 1, arise under A, the ordinances of the municipality, or B, the municipal court has concurrent jurisdiction with the justice court of a precinct in which the municipality is located in all criminal cases arising under state law that arise within that municipality's territorial limits. Well, I don't see anything about Class C misdemeanors, so they don't have jurisdiction. In this section, an offense which is punishable by fine only is defined as an offense that is punishable by fine and such sanctions, if any, as authorized by statute, not consisting of confinement in jail or imprisonment. And that's Texas Government Code, so that's talking about a municipal court. But it doesn't say they have jurisdiction over anything that's got to be. It says they only have jurisdiction over criminal cases. And a county attorney, again, will represent the state in all cases. And they never have, these cities never have a county attorney. So that's you can go home after that. Now, malicious prosecution. Although probable cause may not be inferred from malice, malice may be inferred from lack of probable cause. In other words, if they have no probable cause, it's a malicious prosecution by definition, okay? If they don't have probable cause, it's a malicious prosecution. So what's probable cause? Well, Article 1, Section 9 of the Constitution, of the Texas Constitution, and I guarantee you there's going to be similar stuff in every state, I'll bet you. I haven't looked, but I'll bet you. The people shall be secure in their persons, houses, papers, possessions, all unreasonable searches and seizures, and no warrant to search any place or to seize any person or thing shall issue without describing them as near as may be, nor without probable cause. Without probable cause. They have to have probable cause. Well, probable cause can only exist in relation to criminal conduct. Civil disputes cannot give rise to probable cause. So you get a load of this? If it's a civil matter, they don't have probable cause. So if that cop is stopping you for speeding, the first words out of your mouth should say, "Excuse me, but what's your probable cause for stopping me?" "Oh, you were speeding." "Well, speeding's a Class C misdemeanor, and a Class C misdemeanor is not a crime. And so I say again, what's your probable cause for stopping me, or should I just be on my way?" I'm serious. That cuts to the chase. And if you got stopped for speeding, it's a malicious prosecution by definition. The test for a police officer's sufficient basis for probable cause: did the officer have a sufficient basis to make a practical, common sense decision that a fair probability of crime existed? Once the officer's actions fail to satisfy this test, it may appear that no reasonably objective officer could have believed that probable cause existed to make an arrest. By definition, probable cause to arrest can only exist in relation to criminal conduct. Civil disputes cannot give rise to probable cause. Article 4 of an amendment prohibits law enforcement officers from arresting citizens without probable cause. Arrest made without probable cause violates the Fourth Amendment. And holding involuntary civil confinement as a massive curtailment of liberty is tantamount to the infringement of being arrested and can be made only upon probable cause. If they don't have probable cause, then it is false arrest, it's a violation of the Fourth Amendment, and if they try and prosecute you, that's a malicious prosecution. Because they don't have probable cause. A crime means a misdemeanor punishable by confinement or a felony. A defendant means a person accused of a crime. That's it. A Class C misdemeanor is not probable cause. It's a malicious prosecution. A public servant, and what it is official oppression in Texas. And I'll bet you'll find similar stuff in your state. A public servant acting under color of his office or employment commits an offense if he intentionally subjects another to mistreatment or to arrest, detention, search, seizure, dispossession, assessment, or lien that he knows is unlawful. Intentionally denies or impedes another in the exercise or enjoyment of any right, privilege, power, or immunity, knowing his conduct to be unlawful. If he's got no probable cause, he's guilty of official oppression. This is a good example right here, okay? This is an indictment, if you can believe it. I cut off the important stuff, although it is public record, so I could have left it there. But get a load of this. This is an indictment. Actually, it's supposed to be a bill of indictment, by the way. So with any bill, you tell me, what do you think? Do you think maybe it should say true bill? Do you think? Maybe? And what do you think? The judge went and doctored up this bill of indictment where it says treatment of medical conditions. He added in some people's names. Can you do that with an indictment? Absolutely not. And number 3, an indictment is supposed to have a county criminal district attorney's signature on it. There's no signature there. This is a big-time fake indictment. This is a friend of mine, actually, and we're working on getting his butt out of jail. But the bottom line is he's in jail right now because of this so-called indictment. Matter of fact, another friend of mine told me that he talked to a court clerk, and she says, "Oh yeah, I sign those things all the time." Well, we need to put somebody like that in jail. Whoever this Betty is, she needs to get put in jail because this is a fraud. A bill of indictment is called a bill of indictment. Okay, they may call it an indictment, but that's what it is a bill of indictment. And it must say it's a true bill. If it does not say it's a true bill, then it isn't a true bill of indictment. Think about it. Then it's a fraud. It must be signed by a county attorney, and it must be signed by the grand jury foreman. Now, you know, I was reading some court cases recently, and there's a lot of presumptions in related to indictments, but as long as that stuff is there, then it's presumed to be valid. But that stuff has to be there. And the reason they have the county attorney sign the thing is because he's supposed to make sure that they follow the right procedures. So this is another one. And this is another friend of mine, actually. And get a load, you read at the top, it says, then and there was specific intent to commit the offense of capital murder of J. Fawcett, intentionally shoot at J. Fawcett with a firearm, and the said J. Fawcett was then and there a peace officer who was acting in the lawful discharge of an official duty he wasn't, and who the defendant knew was a peace officer, which amounted to mere preparation that tended but failed to effect the commission of the offense intended. Okay, so offense of attempted capital murder. Okay, this friend of mine has been in jail for 8 years and on a 38-year sentence. And here we have another indictment. Okay, this one actually that's a stamp, criminal district attorney stamp. Okay, that's not a valid signature because it's got to be an original signature. That's Joe Shannon, and he's, by the way, he didn't run for re-election, probably because he should have gone to jail and still might, but because of this kind of crap, because he's supposed to review these indictments and make sure they're properly done. And again, this one doesn't say it's true, Bill. It's a fake indictment. We're working on getting this friend out of jail too, but and he's going to have, you know, big time remedy. But so anyways, he spent a year in solitary confinement. Okay, with these pigs. Oh, don't get me going. You're going to get me going here. So malicious prosecution is Class C misdemeanors in Texas are not crimes. So if it's not a crime and they're prosecuting you for it, then it's a malicious prosecution. And then there's fake indictments, and we already talked about the fake indictments. You see that stuff all over the place. Now, another thing, when you go to appeals, okay, when the appeal courts look for things in the record called appealable issues. And of course, you're supposed to bring out the appealable issues, but the way they can tell if there's an appealable issue is if you object, and the objection has to be on the record. But if you have a liar, well, I meant an attorney. No, I meant a liar, because these liars are just scumbags. These two people back here are in jail based on these fake indictments, and they had attorneys. So that's what you get to have an attorney, folks. Don't have one of these scumbag attorneys. That's what you get. You get to go to jail. They'll sell you down the river. That's exactly what they'll do. You think an attorney's not supposed to know that that's a fake indictment? You're getting me going here. Anyways, and if they fail to object, then you don't have any appealable issues. And that's what happened with this one, actually. Okay? Matter of fact, we even have a videotape of the cops coming up to his attorney and sticking a rifle in his mouth. And I can't remember exactly what they said, but they scared the shit out of the attorney. He didn't object once during the whole show trial. And so we have that video. We're going to be able to do something. But anyways, yeah, don't get me going. And the issue is that if they fail to object, the appealable issue will not be on the record, and so therefore, essentially, you consented by not objecting, or your liar not objecting because he is supposed to object. He consented for you. Okay, that's how liars work. Okay, but the nice thing about war crimes is they cannot be consented to. Okay, and again, it's due process. Okay, so again, that's why the war crimes is so powerful. So you go through the transcript looking for denials of due process, look for anything in the sovereign citizen quick reference because it's evidence of reprisals for political beliefs, war crimes, modified indictments, denials of due process. Was the jury government employees? More denials of due process. Okay? Again, this is all stuff, and these are war crimes. Okay? This is all war crimes. And you can win an appeal. I mean, this is, you know, let's face it. We're working on it with some friends of mine, but it's I think it's gonna work fine, and there's the logic is there. So you know, we'll see. But it's all war crimes. They don't want you knowing about the war crimes. Okay, they absolutely do not. Anyways, here's that Sovereign Citizen Quick Reference Guide. It's uploaded to my group. I already talked about it. This is Title 5, United States Code, Section 552 AA 13. The term federal personnel means officers and employees of the government of the United States, members of the uniformed services, including members of the reserve components, individuals entitled to receive immediate or deferred retirement benefits under any retirement program of the government of the United States, including survivor benefits. And which means anybody with a social security number is federal personnel. And so then, where is it? Well, I had that site. That was said that government employees are not qualified to sit on a grand jury. Okay, if they're not qualified to sit on a grand jury, they're not qualified to sit on a petite jury either. Okay, and so again, that's a denial of due process. Anyways, thanks for watching. This thing has gone on, but it's a malicious prosecution. There's all sorts of. That's all they do. Is I'll bet you could just about defeat anything under a malicious prosecution. These bar members, scumbags, you know, I'd like to see someone get their neck stretched. But of course, I wouldn't deny them due process like they do to all sorts of people. But I'd like to see someone get their neck stretched. Boy, I would, tell you. Anyways, hear that little snap? Oh, don't get me going. Anyways, have a great day. I always grant due process, you know. Just because they deny us due process doesn't mean you do the same to them. You gotta, otherwise you're just a scumbag like they are. You cannot lower yourself to that level. Anyways, have a great day. Malicious prosecutions, that's the way to go, folks. Have a great